Welcome to Straightforward Conversation with Gary Hunter. I'm Gary Hunter. My guest tonight is Karen Harvey, Magistrate of the Athens County Court of Common Pleas Domestic Relations Division. Karen's been an Athens County Commissioner and a clerk and law librarian to Judge Allen Goldsberry, the Common Pleas Judge for the Court of Common Pleas. She has a bachelor's degree in history from the State University of South Dakota, a master's degree in political science from Ohio University, and a law degree from Capital University. My topic tonight is domestic relations in Athens County. Welcome, Karen.
Thank you, Gary.
Karen, the first question I think that comes to mind that the viewers might be interested in is your title is Magistrate of the Athens County Court of Common Pleas Domestic Relations Division. What's a magistrate?
Well, it's relatively new in the state court system in the state of Ohio. I know the federal courts have had magistrates for quite a long time. It's a court official who is appointed by a judge and who has some limited judicial powers. And I suppose, also a magistrate, at least in the state court system, has to be an attorney licensed to practice in the state. There are no requirements right now as to how many years you have to have been licensed to practice before you can be a magistrate, but that's being talked about apparently at this time. And I'm a magistrate. You mentioned one of the judges. I actually work for two judges. I work for Judge Allen Goldsberry and Judge Michael Ward, both of them the judges of the Athens County Court of Common Pleas.
Our viewers might not be aware there are actually two Common Pleas, General Division Common Pleas courts in Athens County now, right?
Right. There are two judges. I work for both of them. And then I also have an appointment from Judge Edward Robe of the Juvenile Division that I fill in down there on an emergency basis when the regular magistrate down there is not available.
Prior to being appointed a magistrate, your title was referee.
Yes.
Could you tell the viewers what the major difference is in becoming a magistrate over being just a referee in the court system?
Referees don't make any decisions. They conduct hearings and make recommendations to the judges. And a magistrate can issue pretrial orders. For instance, in a divorce case, a lot of times there are some immediate orders that sort of stabilize the situation while the divorce goes through the court. It could be a restraining order and an order that you can't sell marital property during the divorce, perhaps a temporary custody order, temporary child support. Magistrates can issue those temporary orders. And then when you get to
they're not reviewed by the judge? Then?
No, they are not reviewed. Well, there is a procedure by which you can stop their effectiveness to an appeal to the judge, but they go into effect as soon as a magistrate signs them and files them, whereas a referee can't issue any of those orders. Everything, even temporary orders, has to be done on a recommendation to the judge. Ohio changed its whole system as of the 1st of July of 1995 and eliminated the referee system, replaced it with a magistrate system. So there are no longer referees. Oh, I think there may be some traffic courts in some of the big cities that still are using some referees, but for the most part, there are no longer court referees. There are now magistrates.
The viewers might be interested in just some basic information about, for instance, where is the Domestic Relations Court located in Athens County, and kind of how does it generally operate?
All right, it's located on the 4th floor of the Athens County Courthouse. There is a hearing room there. Domestic Relations Office, and it's closely adjoining the Clerk of Court's office on the 4th floor. In fact, we work very closely with the Clerk of Court's office because that's how you get a case started in the Domestic Relations Court. You have to file either like a complaint in a divorce or a petition for dissolution or a motion for modification of custody. You file those papers in the Clerk of Court's office, and that initiates the power of the Domestic Relations Court to look at your case.
That brings up the topic. In Ohio, we have two ways that people basically can end their marital relationship. One is the divorce and one is the dissolution of marriage. And the viewers may not be real clear on what the distinction between those two ways of ending a marriage are. Could you elaborate on those a little bit for us?
Yes, a dissolution is classified as a consensual proceeding, which means that both of the parties have to fully participate and voluntarily participate in the dissolution of the marriage. It's also a no-fault proceeding in that there is no need to set forth grounds for divorce. It's simply that two people walk into the court, they have filed the appropriate papers, they have agreed as to all of the issues related to the termination of the marriage, and they are there just to have the court verify the proceeding rather than to make the decisions as to how the property is divided, how the children are dealt with. It's also a much faster proceeding, that the court must, in fact, have a dissolution hearing within 90 days after it has been filed with the court.
Whereas there's also a cooling off period, am I right, too?
30 days. Yeah, yes. We can't have the hearing for 30 days. It must have it within 90 days. So there's that 60-day window in which the hearings take place. Whereas a divorce is not a consensual proceeding. It is filed by one party. You have to have grounds for the divorce, and there are certain grounds, you know, having lived separate and apart for more than 1 year, extreme cruelty, gross neglect of duty are some of the more common grounds that you see. But then there is also a sort of a no-fault ground for divorce in Ohio that's called incompatibility. And a lot of times incompatibility will be used if, for instance, if you have one party that's in California and another one's in Ohio, under a dissolution, they both must be present at the hearing. It's possible to get a no-fault divorce where one party shows up with witnesses and proceeds on the ground of incompatibility, but you just don't have to have the other party present. They have to be fully
informed
that the proceeding is taking place. They've had to have copies of all the papers and so on. But they don't have to be physically present in the hearing room at the time that we do the divorce hearing. And then there are very contested divorces where everything from the grounds for the divorce, possibly even the jurisdiction of the court, the grounds for the divorce, all the property issues, the appraisal of the property, all your child-related issues of custody, visitation, child support, even who gets the tax exemptions for the children, is all part of the decision that's ultimately before the court.
In your view, does the divorce and dissolution proceedings within the terms of a statute vary somewhat from, say, state to state or county to county or even judge to judge?
It definitely varies from state to state. Sure. There are a couple of states that have community property laws, rather than what Ohio has, which is an equitable distribution of property, which may or may not be an equal division of the marital property. Yes, I imagine it does differ from county to county. I've recently just come back from a Magistrates Association meeting where I was a little bit surprised to realize that in some of the bigger counties, they specialize a lot up there, so that there may be one magistrate who hears only property issues, another hears only custody issues. So conceivably, if it's a major divorce, you might appear before more than one magistrate before you finalized it. Whereas down here, although the judges hear a few of the divorces under circumstances, particularly where I have a conflict, if I'm hearing the divorce, I hear everything, property, all the way through all the child-related issues. And then there is some flexibility allowed courts as to some certain kinds of programs that you might have. Two of them that our court has adopted in the last 3 years relate to parents going through the court. One is that we now make it mandatory that every parent going through the court on a dissolution or a divorce must attend a parent education class. The focus of the class is the stress that children are under when their parents are terminating the marriage. And so we try and take parents out of the emotion that's related with the severing of the husband-wife relationship and make them sit down for one session and say, all right, try and put that aside. We're just going to have you focus on children and think about what you might inadvertently do. I mean, we're not there accusing parents of trying to be bad parents. Many parents, and most parents are very good parents. But a lot of times they do get caught up in the emotion and they're not thinking really about how this might be stressful and in what ways. So that is one of the things that we have done, and it has in fact been a very successful program. Just this last week I got an article that was written up in a national family conciliation court journal about the program. We run that in conjunction with Athens County Children's Services.
So there's room for judges to specialize or tailor their own process to what is needed in their county.
That's right. You don't have to have that, although of the maybe 15 counties in the state of Ohio that have it, the success of the programs has prompted someone to introduce legislation to make it mandatory in every county in the state of Ohio, but we're sort of ahead of that one. The other thing is that we also have a mandatory mediation program that we give after a contested divorce is filed, if there's children involved. We give the parties a certain amount of time to try and settle the child-related issues themselves. And then at about 3 months into the process, I'll schedule a pretrial conference and have them give me a status report. Have you solved the child-related issues? If not, we do an assessment as to whether or not these parties are appropriate for a mediation procedure. And we have some highly qualified mediators. They are not attorneys. They could be, but in the case of our court, they've had 40 hours of specialized training in mediating family disputes. And we do assess them because there are some people that, for individual reasons, may not be appropriate. For instance, if there is domestic violence present in the relationship, then the theory is that you have unequal parties here, and it wouldn't be appropriate to send them to a process where the underlying theory is that you're dealing with equals.
Let me interrupt you there. We're going to be back after a commercial break here, Karen and I will. When we come back, we're going to continue this dialogue about the innovative mediation program we have in Athens County, and I want to get into how you decide who gets custody of the children, too. Welcome back to Straightforward Conversation. Karen, before the break, we were discussing the rather innovative mediation program that we have here in Athens County. Do the statistics bear out from this program? Has it been in existence long enough to have some statistics to show that it's working? Well,
it works at various kinds of levels. And sometimes I think that it works just because if both of the parties are represented by an attorney, I think the attorneys maybe are going to work just a little bit harder during those first few months that the divorce is filed to get those child-related issues settled so that their parties aren't sent off to a third-party mediator, which is an additional expense for them. It's an additional involvement of time. And that's fine with me and with the judges, as long as the issues are settled without having to go through what can be the very negative process of a full-blown litigated custody hearing.
Do you have the feeling sometimes, like I do, that the parents are using the children as a weapon or a means of serving their own purposes in a divorce proceeding?
Unfortunately, yes. I think there are instances in which the emotion involved in the husband-wife relationship has left one party, maybe there's been an unfaithful spouse, and there's a need to retaliate. Well, if you're going to leave me for whatever reason, then I'm not going to let you see the children. That's one of the primary purposes that we do, that within the first 30 days we try to get parents to that program at Children's Services to say, think about this and what it can do to the children if you use them to try and address your own emotional needs. I have had a few cases where I think that there may be attempts to get custody because of financial aspects. You have to have the children to apply for public assistance. Child support is very much determined by who has the children. And say there's 3 children in a family, if one of the children goes with one parent and 2 with the others, there's going to be a less payment of child support to the one with the 2 children than if that parent had all 3 children. And so we try very much to divorce those issues of, deal with the custody and the visitation. But it's awfully hard to separate some of those issues.
I believe I'm right in saying that the Ohio law basically mandates that the decision on who gets child custody is supposed to be a fairly equal decision in your mind. But don't you think in reality that child custody favors the mother?
I'll only answer that yes, because I think that what happens is that many times we see fathers coming into a court who have, prior to the court proceeding, allowed a situation to become where the mother is the primary caregiver. Those habits, the patterns, it's always been mother who gets up and gets the kids breakfast, gets them off to school, who goes to parent-teachers conferences. when that kind of a pattern has developed prior to the divorce, then I think that it's maybe too late to start and totally overcome if it's been a total process of one parent. But otherwise, the Ohio Revised Code anymore is fairly explicit in that both parents come to court on an equal footing. Both have the opportunity to present it. There are certain ages at which children's psychological, depending on the sex of the child, the psychological needs of the child at that given age may tend, and you could have say a boy who's like, say, 6 to 10 years old, who maybe father has never been the primary caregiver, but the psychological needs of this child at that stage in his life are such that father is very definitely the appropriate custodial parent.
So you're telling me that you think it's fairly equal. What about if there are allegations of alternative lifestyle involved in the battle for custody of children?
Well, I take it by that you mean that there might be a third party that's involved. Is that what you mean by alternative lifestyle?
What I mean by alternative lifestyle, there's an allegation by either husband or wife that the other is engaged in a relationship of the same sex.
Do you know, I've been doing this for 4.5 years, and that has never been an allegation in one of the divorces. You read the case law. It is definitely there in the case law. And there is case law in Ohio, in other courts, that says that that is not to be the primary consideration. And there have been awards of custody to parents. But I can't think of a time when that has really been a major issue during the time that I have been either the referee or the magistrate for the court. More frequently, what you see as an issue is that mom has a new boyfriend or dad has a new girlfriend, and there is an allegation that that person is an inappropriate parental figure for the children. Or I will see post-decree situations where the parties have really gotten along quite well in sharing the children until mom's boyfriend moves in or dad's girlfriend moves in, and suddenly the whole visitation arrangement falls apart because you now have a new significant figure within the relationship. And that's far more common than the same-sex relationships are.
So it's not really a factor as far as you're concerned?
It certainly could be, and you're aware of it, and you read all the case law that comes through and you expect it to come, but I haven't had it as a factor, no.
How would you deal with it if you did have it before you?
Hopefully straightforwardly, and take and look at all the same factors are there. You look at how well the child is adjusted to home, how well the child is adjusted to school, the type of relationship that the child has with both of the parents, whether there's extended family, whether the child has any special and unusual needs, whether either child or other parent intends to move out of the area, the geographic proximity of the parents, their work schedules. All those are the same, not directly related to the sex that's involved with the parent.
I think we've all heard the comment that if both parents come to the court essentially on the same footing, same financial wherewithal, same temperament as a parenting skills, etc., essentially the same, that maybe the son belongs with the father and the daughter belongs with the mother. Two-part question. How do you feel about that concept? And if you feel that that's an adequate basis for parceling out custody, how do you feel about split custody situations?
Okay, let me take those one at a time. I think that there are probably ages in any child's life when one or the other parent may be the appropriate psychological parent for them. There's also some theory that if it's a very young child, the appropriate parent is the mother. That, it's called the tender years doctrine, and it's far less prevalent in our courts, as many fathers have come to court and said, hey, I'm capable of taking care of a baby. I want my share of time with that child. And then there are ages at which, that frequently a teenage girl is at a time when she needs the role model of a mother. I already mentioned boys, 6 to 10 in there, that there supposedly is a strong psychological need for a father figure in their life at that time. But I've also seen times when the most important parent in a teenage girl's life is her father. And we have had fathers who have stepped in and taken custody of those children, or mothers who for some other reason say, you know, I want my boy to understand some of the values that women can give to their life and not just have it be all male-oriented. And I think it's important that I have significant time with my teenage son or whatever the boy's age is. So it's there. It depends a lot on the child. There are a lot of times that we use 2 additional ways of getting to the crux of custody cases. You know, the court is pretty well tied. As a hearing officer, you're caught in that hearing room. Mm-hmm. Parents who sit in the witness chair have a special inclination to present themselves in the best possible way and to present the other parent in the worst possible way, because this is an adversarial battle between the two. That we will use a guardian ad litem to go out and do a home investigation, go to the both homes. You know, if one of the parents is saying the other parent doesn't have appropriate food, the house is filthy, some of those things are all relative. It may be, if you're just a compulsive housekeeper, that anything is going to not be clean enough for you. So you send people out to do these kinds of investigations. And if it appears that you do have, I won't say serious, but that an emotional or a mental problem may be preventing the resolution of the problems here, we do have means by which we can get psychological evaluations of all the parties concerned and actually have a clinical psychologist make a recommendation to the court. Sometimes the recommendation may just be both of these parents are appropriate parents. So at least you know in that way you've eliminated the concerns that you might have about the mental state of one or the other of the parents.
Well, stay tuned. Karen and I will be back after this commercial break. When we come back, I want to ask Karen some more questions about custody, such as the grandparents' right to visitation and out-of-state parenting. Welcome back to Straightforward Conversation. Karen, before the break we were talking about child custody issues, and one of the questions that I get asked as an attorney is, do the grandparents have any rights to visitation? They feel like they're, should have those rights, and sometimes I know they get some rights of visitation and sometimes they don't get as much as they think they're entitled to. What really is the law in that area?
There is a law in Ohio that permits grandparents to intervene in the termination of a marriage or to come in at a later date after the termination of the marriage and specifically request that they be granted their own visitation schedule with the child. And the only time in Ohio that grandparents have that right is when a marriage has been terminated. I mean, there's grandparents out there who don't have the relationship they want with their children and the marriage is still intact. And courts have said that grandparents have no right to intervene in an intact marriage. I've had quite a few hearings on grandparent visitation rights. I think sometimes I see it as very important and that the court step in and grant those, that the emotional problems that came out of a marriage can carry through to grandparents. I have also had grandparent visitation rights where one of the parents is deceased and the grandparents of the deceased parent have been cut out of a relationship with the children and so come to court and ask that that be established. I have had grandparents in where one of the parents is in prison and their relationship with their grandchildren has been cut off as a result of that, and they have asked for visitation rights. I think the one thing that the court has to be a little bit careful of when you're dealing with, and it doesn't just have to be grandparents, step-parents after a lot of times if a step-parent has had like an 8 or 10-year marriage with stepchildren, they have formed a very tight bond with the child and want to continue that in a visitation schedule. What the court has to resist is, and the analogy I use is that you can't take a child, it's not a piece of pie, divide it up into 7 pieces and say, Monday's mom, Tuesday's dad, Wednesday's is this grandparents, Thursday's is another grandparents. I actually had one where when it was all time over, I was asking myself, when's the kid's day? I mean, when's this child's day to be nobody's property?
Right.
And I think that you really have to resist that if those grandparents have a good relationship with their child, the son or the daughter, and that son or daughter is receiving adequate visitation time, then maybe a separate visitation order is not necessary. I guess another common time where you see it is that perhaps mother's the custodial parent, father lives in California, so the children and the paternal grandparents are here in Athens County. So all the visitation with their son is the children go to California, and so they may want some time because they can't see the children when they're visiting with their son or daughter.
In the time we have left in this segment of the discussion, we've all heard that there are kind of specific general guidelines for visitation. The old rule that if the non-custodial parent gets them every other weekend from Friday night at 6 to Sunday night at 6 and alternating Wednesdays and alternating major holidays and 2 weeks in the summer. One, is that your policy? And two, if that is your policy, does it always work from age 1 through age 21? Or age 18, excuse me, when they become a joiner?
That's interesting because I think the Domestic Relations Committee of the Bar Association is meeting yet this week, and one of the items on the agenda is, do we need to have different visitation schedules for different age children? They do in the big cities. Now, Hamilton County has just adopted a visitation schedule that's broken down into 5 age categories. I don't like any kind of a schedule that's rigid. That people have such different work patterns, their geographical proximity differs, and in fact that is a problem down here that you might not have in a big city. You know, you can live easily within 5 miles of each other in a big city. Down here we're apt to have one parent in Nelsonville and the other in Coolville, and still both be in Athens County, but that's quite a drive to have to, so you don't want to have them, you know, like if it's a very small baby, the father doesn't want to stop by every night after work and spend a couple hours with the baby and then, you know, drive clear across the county. So you have to, no matter what kind of a standard visitation schedule the court uses, you have to be prepared to tailor it to the individual circumstances. So
individuality is the name of the game, really, in this.
Well, it's a lot of times people walk into court. A lot of people come to court without attorneys, by the way, too. And you'll say, well, what type of visitation do you want? And they don't have an answer for you. And it's very convenient for them to be able to say, here's a schedule that has worked well for a lot of people. Take a look at it. And many of them accept it because it is. It's got all your holidays alternated. It tells how soon, you know, how you work out extended visitation in the summer, and it's convenient for them to have that.
Well, Karen, this has been an interesting conversation, and obviously there's a great more we could talk about, and maybe we should have you back on another show. But for now, this has been Straightforward Conversation with Garry Hunter, and good evening.